All right, welcome to our first breakout session here this afternoon. Exciting multimedia specialist panel. We're going to be talking about using skills for high-profile cases. You know, we had Bill talking earlier about food safety nightmares, so we're going to talk a little bit about how to help manage those types of situations in the media, and then also how to use the media to help grow your food and agriculture practice. For those of you that don't know me, I'm Carrie Rinker. I am the only food and agriculture lawyer in New York City, and so it usually follows with a joke about a tractor in Central Park. So I am currently the chairperson of the American Bar Association General Practice Solo and Small Firm Agriculture Law Committee, which is quite a mouthful. And we have a slew of fantastic panelists here today, all the way from Las Vegas, Nevada. We have Greg Brooks from the West Third Group. He's going to be our kind of Western perspective on all of these issues. He's focused on communication on advanced complex issues and policies and technical issues to the press, public, elected officials, and stakeholder groups. He has a career history in working with strategic communication and public relations, marketing, public affairs, and journalism, and is also an international speaker on these various topics. And we have Weatherly, who's going to be giving more of like the agriculture perspective on the issue. She is a third generation owner and operator of Trulick Farm, did I say that? Which is a diverse growing operation in Timminsville, South Carolina, which is how far from here?
About an hour and a half.
All right. And the former executive of the South Carolina Fruit, Vegetable, and Specialty Crop Growers Association and the South Carolina Association of Farmers Markets at the South Carolina Department of Ag. And she's also a prior owner of a public relations firm. And last but certainly not least, from New York City, we have Keith Emmer, who is actually a lawyer here that's on the panel. I think he offers an interesting perspective here as an attorney working in public relations with lawyers, both ranging from solo practitioners all the way to the big law firms as well. So he focuses on litigation, crisis communication, and public affairs. And he also has some experience working with FDA regulations and restaurant franchise matters. So today's roundtable discussion, what I have here are some questions that I've developed to kind of spark communication, to spark some discussion. But I want this to be more of an informal discussion out here. Please feel free to interject with your own questions. And just use my questions as sort of a starting point. This session is being video recorded, so we've got the camera up there. So if I might repeat your question, so that way we make sure that it's clearly articulate for the video recording. So first and foremost, let's just lay the groundwork. What is the difference between advertising, marketing, and public relations? And specifically, what should attorneys be doing with each of these three? Who wants to start?
Okay, so you're not going to just call on us?
Yeah, no, you guys jump in.
Well, I would say that it's the difference between third-party independent magnification of your messages. That would be public relations, tapping into the credibility of others and the influence of others. Marketing is a discussion of features and benefits, sometimes current, sometimes aspirational, typically designed to drive sales, but there's also marketing simply designed to drive awareness of an issue or a brand. And advertising is paid media. If public relations is earned media, you're working to get that imprimatur of a third party, advertising is something you pay for and you fully control the message and the format.
Either one of you have thoughts on that?
Yeah, I think so. I think that to me, the biggest difference between advertising and PR is that you pay for advertising and that you control it. And for PR, you don't pay for it, at least not directly. but you also don't control it, and that has both its benefits and its drawbacks. It has benefits in terms of credibility, and of course it has drawbacks in terms of not having control. You don't have so much control over the editorial output, so you have to just be more careful with it. But that being said, I think it's of course a very valuable tool.
Right.
So,
And just as a final point, the lines are more blurred between those three silos than ever before. You can go out and purchase advertising that looks an awful lot like earned media. You can have earned media PR relationships that ethically or otherwise involve an exchange of money. So it's a bit of a muddled landscape these days.
All right, anybody from the audience have thoughts on that? Or any additional questions on just the trio there of advertising, marketing, and public relations?
Yes, I wondered, especially now that these lines are more blurred and with the dirty places are on the internet, or it ends up on the internet through the acts of third parties, especially if you have a multi-state practice, how do you avoid running afoul of the various state ethics rules?
yeah.
That's a question you're very well qualified.
More. So it comes down to a lot of the concept of it is control. So if it's something that you control or can have exercise some control over, then yes, you have to be careful. Social media, certain aspects of social media bring a lot of ethical considerations into play. Things like AVO, where you can go and if something on there is wrong in your profile, do you have a duty to go and fix that? Well, you may. Obviously, your website, anything, but editorial is, if it's really truly editorial, it's out of your control. So anything that you control, you have to be especially careful. And then, of course, if you're involved in litigation, I think the obvious things, or maybe some things that are a little bit less obvious, like who is your Facebook friend? If you're investigating, how much can you use social media? I mean, it's a little beyond the scope of this panel today, but yes, you do have to be careful.
All right, let's move on. Let's talk about reputation management, which we're touching on just a little bit here in our keynote this morning. But, first of all, what do public relation professionals do? And should food and ag lawyers be sending press releases? Thoughts on that?
Should you be sending press releases? I suppose the answer depends on the press release. There are a bit of landscape. Whether you're talking about your local daily newspaper or a specialty publication for attorneys or a specialty publication in the ag industry, the ratio of journalists to publications has been declining for years and is continuing to decline. Any member of the media that you come into contact with is more overworked and more flooded with information than ever before. And so if your press release is on a trivial matter or on something that is not going to be clearly compelling, then I would say it's at best a waste of time, and at worst you're establishing a reputation as somebody who's not very savvy with the media. Now, having said that, do you send a press release when it will clearly help the public opinion, in the court of public opinion with a client? Potentially. Do you send a press release when you're trying to manage the reputation of your own firm and build yourself up in a position of thought leadership, and again, you have something compelling to offer? I would say yes. My number one argument for that I give to attorneys who are interested in pursuing a higher profile of the press for working with a professional PR person is that most people outside of the media and PR do not have a clear idea of how compelling or important their story is. And you need that filter. You need some trusted counsel, much as you're trusted counsel to your clients and employers, who can say, No, not at this time, not that message, because that's not going to help you.
Any thoughts from the audience? All right, so I have a secret dream, and go ahead.
What do you mean by reputation management?
Well, let's ask the presenters. What does reputation management mean to the three of you?
You might, I mean, I really don't have a public relation, and I have laryngitis, I'm sorry. It's convenient. But I was a reporter before I went into full-time agriculture, so I'm not really as much PR as I am the person I want to get the story. And about press releases, yeah, if you don't send them, like he said, I wouldn't have had time, you know. Nobody really gets a beat anymore. Our beat is everything, you know. Who's available in the moment to go get that story. So, yeah, don't send frivolous ones, you know. Make sure you get it vetted and have a good story, but otherwise, you know, how am I, the reporter, going to know, you know, what's going on? And we'll get into more of that later with how to deal with the press. But
in a perfect world, you establish relationships with the media that are relevant to you, so that you are trusted when you call them, and when they have an issue relevant to you, they call you. Trusted relationships rarely come from just sending press releases over the transom. You know, like many of you who are, if you're involved in a practice in business development with that practice, you know that relationships are everything. It's the same with the media. I'll give you a perfect example. I have a client who shall remain nameless to protect them from their own stupidity. They demanded a DC congressional beat press release go out this morning. 168 reporters, all at publications you've heard of, all in very high-profile roles, anchors, bookers, things like that. They were counseled not to send it out. It was not the right time, it was not the right message they wanted to send out. 168 press releases went out. No phone calls, no emails off of that. Timing and message are everything.
Yeah, I think I'll just add, there's a sense that people have that, you know, if I tell people I work in public relations, oh, you send press releases, that's the first thing they think of. And the answer is, it's really not very often, actually. There are a lot of other ways to get in touch with journalists, and if you are sending a lot of press releases, busy journalists are going to begin to ignore them. So the news should really be pretty significant. It could be a successful litigation outcome, it could be a big corporate deal, some significant office news. It should really be something pretty significant. I mean, we don't send so many, relatively speaking, and fewer than we used to. And a lot of what we do is just reaching out and getting in touch. And the other thing is that press releases require, especially if they involve a client, they take time. You have to get them approved. They're usually they're an official message. You have to get quotes approved, so they could take a lot of time. And sometimes, or very often, depending what the matter is, by the time you get the press release out, the news is kind of passed or you're behind the curve. So we really don't send so many. And I would encourage you all to think about other ways of getting news out most of the time, or developing relationships with journalists. You're not developing relationships with journalists primarily through press releases.
Right. Yeah, back to your point about reputation management, Carrie. Crisis management to me is, we've spilled the milk on the floor, oh my gosh, okay? It's all hands on deck. It's very expensive when attorneys, particularly litigators, get involved in it, and it's very expensive when crisis communications people, such as myself, get involved in it. Reputation management is the ongoing act of creating a positive awareness and goodwill of your clients, if you're doing it for your clients, or of yourselves. It covers many, many different sub-disciplines. It's everything from pushing down bad links in Google with good content to developing a higher positive profile in the community for clients who are at risk of something bad happening, so that they've got that goodwill to tap into. If crisis management is the fire department showing up, reputation management is that State Farm agent selling you that very boring property insurance that is probably going to save your bacon one day when the day goes
Great. So when should an attorney be prepared to go to the press about a current court case that they're working on for a client?
Immediately. That doesn't mean that you go out with it immediately, but you should be prepared immediately. Especially, you're referring to a court case specifically. If something is in court, it can really be in the media at any time. And of course, depending on what it is, it can be in a lot of media, and you may not be ready for that call. As soon as you take on a matter, you really should be thinking about press, particularly if it's a litigation matter or something that has the potential to turn into litigation.
So what does being prepared really look like? You know, I'm a solo in 3/4. What does it mean for me to be prepared to go to the press?
Let me, as an example, tell you what the Institute for Justice does. They are a public service law firm / think tank in Washington, D.C. It's a very large building full of very good lawyers who sue the government on a variety of subjects. When they decide to take on a case, before the first deposition, before anything else, they sit down with their communications professionals and they figure out what's the story. What's the story arc? What do we want to tell people? What do we not want to tell people? What's the desired outcome? So they're thinking of their communications from the very beginning. I completely agree that once you're in court, you need to control your message. You need to have a plan to talk to the press or to be ready to talk to the press if they call you. Because if you don't take that control step, you're going to be in a reactive mode and the control is taken from you. I would argue, however, that I like the IJ matter better, or the IJ approach better, in that for cases that you don't know if they're ever going to get to court, maybe you guys settle. It's still very useful early in the process to figure out a handful of key messages, have some backup material to document them, and have an idea of what the key the points are you want somebody to walk away from this narrative with, whether it gets to trial or not. It's a simple exercise. I used to work at the Goldwater Institute in Arizona, and we had a constitutional litigation function. Again, attorneys suing the government, but that's what every case had a one-page story summary file in the front of the case file, so that any attorney talking to any reporter, if the case came up, they knew their points.
Out of curiosity, who here has had any form of media training? A few?
The good news is I do media training.
No, so that leads me to the next question. Should attorneys get media training, and if so, where can you even get it?
You're up. I would think of going to the media the same way you would think of preparing your clients for a deposition. Think about all the points you want to make, the points you don't want to make, the questions you're going to get the questions you want to get, the points that you want to make regardless of whether you get the question, and the tough questions that you're inevitably going to get. So, if it's TV, you have to think about clothing choices and expressions and gestures and things like that. Your PR professional should be able to help you with media training, but I would think of it that way. It's that important also because, particularly in a litigation, the potential for risk and reward in the media can actually very often be more than the potential for risk and reward in court in terms of dollars, particularly if your client is a consumer company. Yeah, you have to really prepare for that, and you prepare for that just as you would for a deposition. That's what I would say.
I would add that if you are a solo or a small practice, and you have a local PR function that you work with, maybe somebody who's doing 10 hours a month for you or something, you can get some basic media training from almost any PR person. If you are working in a larger practice, or if you want a group of attorneys in your office to have consistent training, it's probably best to get somebody who has trained and worked with a attorneys before. You don't want to be anybody's set of training wheels. And attorneys do have very specific issues. You have ideal background for this sort of thing. The way I handle it is I have, when I train, I bring in a reporter who will often say he hates everything I say. It's like you're getting the reporter's perspective. And I bring in an attorney who has done a lot of high-profile media and can talk about that perspective. But whether you go that route or some other route, I really want to stress getting somebody who's done the work before.
And yes, we had a question?
I have a different kind of question, actually, it's different than being prepared to go to the press, because, in the internet age, YouTube and Twitter and all of those types of things, you can do live webcasts where, for example, I'm working on the Syngenta case, and we're planning on doing a live webcast where we take questions from, we do a short commercial, and then we take questions from the viewing webcast farmers, basically, and take questions about the Syngenta case itself. What kind of things do you have to worry about as far as professional ethics rules? And what kind of things do you have to worry about as far as, the questions that the answers that you give on those types of questions?
So, and I'm not going to repeat that entire question, so hopefully one of you got it.
So professional ethics rules for essentially a webinar, I mean,
Correct.
Or social media.
or social media.
Usually, if you send a letter, you have to have, for example, in South Dakota, you have to have an ad says advertising material on the top in 18-point font, and you have to send it to the South Dakota bar 30 days before you use it. That's a rule on mail. I don't know of any kind of rules on a webcast, because I don't think the rules were written for that technology.
Yeah, let me put a disclaimer. First of all, I'm not an ethics attorney, ethics expert, and I'm not an ethics attorney expert in every state, right? And so you have different states have different rules as well. But it's what it sounds like to me. I mean, it's really not so different. What you just described is really not so different than a press conference. It's just kind of using more updated technology. So I would just kind of apply the same rules. The biggest difference is just like any prepared statement that you would make during a press conference, that you would think through that from a legal perspective and an ethics perspective and everything else. Now, of course, any visuals you use, and everything now is that's online lives there forever. So you just have to think about that. It's a little too general to give more specific guidance, but think of it like pretty similar to a press conference.
So are there any rules that apply in a press conference that one needs to be aware of that would likely apply to the webcast?
I mean, don't say anything the judge told you not to say.
And I'm sorry, did you have a question?
Yes, and, this is, I guess, kind of similar to his, but maybe backing up just to the traditional. I had a scenario a couple of years ago where I was representing a group of farmers who had been sued, and, and the lawyer for the plaintiff just comes out, and, he makes a statement to the area newspaper that just bashes them, talks about how they're evil people and did all this and that sort of thing. And, and I didn't respond, at that point I didn't know what you could do. Where's the line? Maybe Carrie, you know this too. Where's the line when you say something, but to say basically to defend your people, but without maybe breaching, any sort of duty you have to them to keep your mouth shut?
Any thoughts on how to respond? What's that saying about don't throw mud or sling mud? Okay.
I always advise my clients to talk about the case, talk about the facts, don't talk about the people, even if the other people are talking about you. And that is, I also am not qualified to talk about ethics across state lines with regard to attorneys, but in 25 years, that advice has not run afoul of any state bar issues. Because if you're talking about the case and you're talking to the press, the press is it's different if you're talking to your friend and your friend goes and writes a long screed on Facebook about it. Okay, but the press is a different class with highly protected access to their speech, and so we don't. As long as you're talking to what anybody would consider any reasonable person would consider a member of the media, I think you have a wider latitude than you might in other conversations.
Well, you know, the media has more latitude than you do, though. The media have more latitude. So you don't want to be getting in a situation where you're defaming anyone, obviously. So, you know, you do have to be. You have to be cautious with any kind of public or written statement or any kind of statement you made to the press, because that could also be perceived as coming from your client if you're in a litigation situation. But I mean, generally speaking, I think you're going to be thinking more about what's good for your client to say, what you should say that's good for your client, yeah, I mean, you don't want to say anything that's going to upset the judge. I mean, the rules on this haven't really changed. You just have more opportunities to mess up because social media gives you so many more opportunities, so many more channels. So once you're adding that, there are just so many more different ways that it can get out of your control.
All right, to go ahead and move along. Did you have something, Bill?
I just wanted to go back real quick, back to the webinar.
Okay.
And in comparison to that, to your press release. I mean, from an ethical standpoint, I guess I would worry about the difference being who's going to be on the other end of that webinar, who will be solicited to get on that webinar and ask those questions. I guess from an ethical standpoint, is there a solicitation in your state bar? Would it be a question of how you're soliciting or whether you are soliciting specific individuals? I guess it's different from, I guess, the more general press release atmosphere is who have you invited to that webinar? Thanks.
Probably so.
We will be sending emails out to potential clients.
Yeah, so I guess my primary point of concern would be the guidelines around solicitation.
So when you're doing business development, you just have to look at your state bar rules about attorney advertising. So that would apply.
I'd love to have Weatherly's perspective on this next comment. But Keith previously mentioned, really build a relationship with the journalists. And my question is, what's the best way to contact a journalist or to pitch a story to a journalist?
Okay. Well, like the guys already said, it is nowadays more about the personal relationship with, so if you, decide, do you want television, do you want print, do you want it all? And then, like say, with print, they still sort of have beats, a little bit at the newspaper. So if you've got like a environmental or agricultural based issue, you're going to try to find that guy or that gal that writes all those feature stories, whenever there's an environmental story. In television, I mean, you just, who do you think will do the best job, and try to reach them directly, and you can get their contact information, all reporters' contact information really easily online. So it's
All right, who here has an email distribution list? Anybody use Constant Contact or MailChimp or anything like that? Okay, I do, and I'm sorry if you've got my spam. So my question is should I add journalists to my email distribution list and just hope, that it gets out there and they know how awesome I am and they contact me from my email distribution list? Or furthermore, is that even professional?
I mean, maybe if the journalist knows who you are, beforehand.
Yeah, I wouldn't add anybody to your mailing list who you don't know at some level. We don't add strangers to the mailing list. That's a rule.
Right.
What I do with journalists is, with a new client who wants a relationship with reporters that I don't know, is first of all, do a little research. Go look up their bylines, see what they're working on, see if if you can ferret out any themes in their work, and then if you are working with a PR professional who's got access to a media database, you can sometimes find out things like, well, they prefer to be pitched on Twitter. A lot of journalists prefer to be pitched on Twitter these days. Or maybe they don't want The theme here is find out as much as you can. And then your first conversation, if you're looking for that relationship, you're not looking to just get news about a case out there and hit and run and walk away. Call up, if calling's appropriate, call up and have a conversation. Say, this is what I do. I've noticed you've done this, this, and this over the last 6 months. I wanted to let you know I've got these resources available if it's helpful. I don't like the metaphor, but it's not a lot different from sitting down next to a stranger on a bench, right? You can come on too strong and blow a potential friendship. You can sit there in stony silence and hope they say something first. That doesn't usually work. Or you can use some of the skills that, especially those of you who are litigators and do trial work, have learned some of the communication skills you've learned to draw out information and start a relationship.
So I've had interviews on things that are divisive topics, maybe on ag-gag or antibiotic regulation, and my heart starts beating a little faster because I'm afraid I'm going to get misquoted. So what suggestions do you have for attorneys like myself that are afraid to be misquoted on divisive issues?
You can say the same thing.
Let's let the journalist
You
tell
can
you.
say it on television, say the same thing over and over again, just different ways. Yeah.
So that's the trick. You just
Keep repeating yourself to this, answer this question, every question the same way, and you probably will not be misquoted.
Look, it could happen. The best way, obviously, is not to talk, assuming you're going to talk. You can avoid it by having a written statement. We do that a lot. It's very hard to misquote someone if they're sending out a written statement. So I recommend that if you're really worried about it. Responsible journalists will sometimes ask you to verify your quotes in certain situations. One thing that I would warn you about is don't expect that, and and also if you don't want to be quoted at all, make sure that you establish that before you start talking, not after, because journalist has no obligation to not quote you on something that you've already said.
If I may, quick question to the audience. When is it okay to say no comment?
Always?
It may not be the best.
I would argue that it is never okay to say no comment.
Really?
You always have something you can say that will advance your client's message or shut down a negative line of questioning, steer it over to a positive line of questioning. No comment just sounds defensive. You may have the net effect of having made no comment, but generally you don't say no comment.
No comment means indict me.
Ted?
Mine works a little better because I have previous experience working in the federal government. It's just to say, I am not allowed to comment on that at this time. And that way, it's not me making the choice, it's my agency that's making the choice, which in fact is the case.
We train message discipline, which is very similar to what you heard a moment ago. First of all, anybody who's ever seen a story in the paper or on TV about a topic that you really understand knows how wrong the press gets things. It's not just you, and it's not just an isolated case. The press is forced constantly members of the press are forced to become instant experts on new issues, new topics over and over. That is not an environment that makes for perfect accuracy. And so if you have a key point to make or a key fact to make, message discipline is nothing more than learning how to pivot the conversation back around to those points you want to make, rather than simply being reactive to the reporter over and over again.
And a comment in the back?
Two things. First, on the no comment deal, are you basically saying have your default line of statement, and it's something that you're really not prepared to discuss for whatever reason, transition the discussion to your default message?
Right. It's called bridging. And again, one of the reasons I like working with attorneys is most of them are fairly good at it, because especially the ones who've done, done cross, they're pretty good at coming back around.
At least we like to think so.
Yeah, exactly.
But the second thing on getting misquoted, the original question, here's something that I've dealt with, and I've had situations where I thought the reporter either got the story wrong or did not say what I said correctly, either generally or specifically. If it's something that has some continuing coverage and it's a reporter he develops some rapport with, what about calling them and saying, hey, look, I think you got it off a little bit.
Oh, absolutely.
Sure.
And let's try to, next time there's a news event in the case, let's try to make certain we correct it. And the time or two that's happened to me, I think they've been fairly receptive.
And the reason they're receptive is that particularly post Woodward and Bernstein, there's a popular image of the crusading reporter who wants to right the wrongs in the world. A lot of reporters, they just want to do a good job. They don't want their boss to yell at them. They want to go home on time. To the extent that you can maximize the possibility of those things happening, you're being helpful. What you're suggesting is being helpful because you're talking to the reporter and not going over his or her head to the editor and making a federal case out of it. Yeah.
Hey, let me better educate you on this. And then that level of education hopefully comes to bear the next time there's a story on the top.
So going a little bit backwards, we were talking a few slides ago about being prepared to go to the press. And I'm curious if part of being prepared to go to the press in dealing with court cases and clients is getting a written authorization from your client from the very get-go on whether or not you have permission to go to the press or not.
Certainly, if you're going to be putting out press releases, anything written, you should get written authorization from your client. But hopefully you have a relationship with your client where they trust you. They're trusting you in court, they're trusting you to represent them, and you would expect also they would trust you to talk to the media if that's something that you should be doing. But it's definitely something you should be discussing with them. I don't think you have to be getting written authorization from them every time you talk to a reporter, but they certainly should know it, and your relationship with them depends on it. Sometimes what a PR firm can do is they can run a little, kind of be a barrier, run a little interference for you. Sometimes you may be in a situation, I mean, we have a situation now, and it's not uncommon, where our client, my client, which is a law firm, they represent actually an insurance company in a subrogation suit. It results out of a very, very large pharmaceutical heist, which made a lot of press. You would have heard of it. Nobody particularly wants a lot more press on it, but at the same time, there's a recognition that pressure on the defendant, which is the security company, will get them to perhaps be a little more flexible in court. So you kind of want to get press, but the lawyer can't talk. How do you go about doing that? So there are ways that you can do that. You can make sure that the story is getting its appropriate coverage, but the lawyer can't be quoted. So PR firms can be helpful in terms of getting in between you and your client.
In terms of getting client permission, in the public interest law cases I've worked on, we make sure that the plaintiff signs a blanket release that up front when we take the case, and that allows us to talk to the media on his or her behalf. It allows us to set an expectation that they will talk to the media, provided reasonable notice. We don't make up quotes for them, but we are able to talk about the case on their behalf and get them in front of the camera. And we also get certain visual assets. We'll get a good headshot on file and things like that to provide visuals for the press. It's not a bad practice if you know there's a likelihood of a case going to the press, just to have that on file.
But to clarify, you're getting a release, but as the attorney, if you're working for the attorney's not getting a release necessarily from their client.
Well,
right? They
I'm
already
get-
have a retainer.
They have,
they're the retainer
they
letter.
have a retainer, but as part of what I'm saying is, as part of the process of taking on the case, there's a one-page release that the attorney makes sure the client signs.
I guess the way I'd put it is that if your client is going to get weirded out by having a reporter try to talk to them or talk to anything in relation to the case in any aspect, if they're going to get weirded out because you didn't warn them, you should, I guess, talk to them first, because as a reporter, once I get wind of that story, I'm going to find it out, and I'm going to do it every way I can. I'm going to talk to their dry cleaner, I'm going to talk to whatever, you know. So if that's going to weird your client out, maybe you should tell them first, so, yeah.
The clients should not be surprised in this situation. It's kind of the bottom line.
All right, let's talk about the public relations nightmare. We were talking about some food safety problems here this morning. You know, for me, I'm scared to death I'm going to have a client come to my door one day with, you know, that was, had an undercover, you know, employee in a YouTube video that got posted online, and all of a sudden I'm now defending them with, you know, alleged, you know, animal cruelty violations. What do you do as an attorney when you've got something that's just gone viral all over the news and all over social media, and you are that person's attorney? What should that person do?
Hopefully you've had a chance to be prepared. I mean, there are different situations. There's the situation where you can see it coming, and there's the situation where it comes completely out of the blue. I mean, look at what Amazon is dealing with. They got an absolutely brutal story in the New York Times about how horrible it is supposedly to work there, and then they had to think about how they're going to react to that and respond after the fact. You know, hopefully you have an opportunity where you have a list of media contacts that you can go to them when, so you can react quickly. If you've had some time to prepare, it's obviously better. I mean, have a plan in place. It's like any other kind of disaster planning. Have a plan in place, a chain of command, who's going to be speaking when something happens, what will you say, what will you not say. If you can have that, you'll be in a lot better position to deal with it. You won't have to be completely behind the eight ball when it happens. I mean, if your clients are large companies, they probably already have that in place. You should know who you're dealing with internally, have an external PR firm. Sometimes it's helpful, sometimes if it's a very difficult situation, just like GCs will hire outside counsel for certain situations, internal marketing departments and internal PR departments at companies will hire external PR counsel, because it can sometimes just be too difficult if there's a sort of a crisis situation. You know, they don't know what's the next call they're getting. They want to be able to do their regular activities, and they can't do it. So you can direct all those calls to an outside PR counsel if it's about a crisis. That being said, once you're doing that, of course, you're acknowledging that that's not something you can manage internally. So it's pretty big flare-up by then to be acknowledging it. Like you want to say
There's
something.
also the issue of what can be said by an internal person and what can't. One of the reasons you have crisis counsel brought in is because often there are things the CEO or other people in the C-suite need to hear that they can't hear from an employee, or because they either won't take it seriously or that employee is risking their career simply by speaking an uncomfortable truth. If you are an attorney in a practice, I would strongly encourage you to have in your Rolodex have a methodology for deciding when something's a crisis, you know, a quick audit process. And if something is a crisis, I suggest that you have a relationship with outside counsel, crisis counsel, that you can bring in on behalf of your clients. One of the dynamics that happens, particularly in very public crises, is a lot of firms and individuals crawl out of the woodwork if you can, imagine the number of phone calls the city manager and the mayor of Ferguson, Missouri got from every two-bit communicator who thought they could help talk them out of that crisis, okay? When the streets are on fire, that's not the time to be figuring out who you're going to work with. So if you work for a firm or if you have your own practice, I suggest that. If you are internal at an organization that is large enough to have a highly public crisis, I suggest you do an audit of your vulnerability to crisis, which is not an expensive thing to do. I suggest if you don't have a crisis plan that you develop one. That's more expensive than an audit, but still not very expensive. And depending on the size of your organization, you may want to do some annual or every 2 years training exercises to be prepared for those things. 90% of the battle space for crisis response is in the preparation. Hasn't always been that way. Used to be milk got spilled on the floor, you had time. Paper wasn't going to come out until tomorrow, might not catch the story immediately. There were fewer media outlets. Now, in the age of social media, your crisis is instant and everywhere. That means that your execution moves to preparation. That's where the battle space is.
I think in food safety, even though once the story breaks, it really turns into a crisis, you have to realize that you've got it's not an overnight crisis from when your client usually knows there's an impending crisis. It takes 2 weeks for the FDA to plate a sample and have, once they've come to the farm and served the farm with a Form 483 and taken swabs, it'll take 2 weeks for that plate to be ready. So your client, if it's like a specialty crop grower or something, they should call you when the FDA is there, and you got about a 2-week window to get ready for your impending crisis, which will be an overnight blank storm. You know what I mean? Because it's food safety, but it shouldn't be a surprise to you. And if you do everything they're saying, which is be prepared, have a spokesperson, or know your plan, and the farm knows the plan, it'll be okay. But you do have a little bit of window from when your client knows it's coming and should warn you. So,
All right, let's move
see
on
here-
to social media. Oh, Ted, do you have a question?
One additional comment, and we're going to touch on this, Stan Wilson's going to touch on this tomorrow in our food safety update. But it's really important in the event of a recall that your client speak with one voice. Too many times we see multiple people in the company talking to the press and they say different stories.
But it's not so much an ag issue, but in franchise organizations, that's a nightmare, because every local media, for a broad franchise crisis, every local media outlet goes to every local franchise, and its message control is very difficult.
Right. And whoever says the most colorful thing
That's
is the person
Yeah.
who's on the news, and sometimes, there's incentives there, or reverse incentives, the kind of incentives you don't want. So, and that's what they're looking for.
I'm looking for that money.
Here she is. Here's the journal. that good quote.
It sounds good.
So-
We'll play it over and over.
Give them something immediately. Go out to them with a statement. You may not be prepared. You don't know what's coming. You may be totally caught off guard, but hopefully you have some chain of command. Go out to them with a written statement, even if it's just something like we're working very hard to see what's happening here and to get to the truth of this, and then send it to everyone who may potentially cover this story, because that way they also and make sure they have your contact information, so they will call you before anything gets written, and that way you have some chance of keeping some control over it.
All right, so Professor Richardson crowned me as the AALA director of Twitter. So anyway, I wanted to say here, there's a lot of different social media platforms out there, and which ones should a lawyer actively participate on?
For marketing purposes? Or, I'm going to answer the question by not answering the question.
Maybe he's the lawyer.
I hate Twitter. I hate Twitter with the fierceness reserved for religious and political debate. Because I believe, as somebody who spent the better part of 30 years professionally communicating, that 140 characters at a time is the road to misunderstanding and perfidy. So I don't know. I frankly don't know what the various state bars have to say about lawyers being on Twitter. What I would say is that people who are into social media want to believe the whole world is into social media. And if you look at the numbers, Twitter is big. Twitter is not as big and mainstream as they would have, as you would think. So from a message distribution perspective on top, for your clients, it's a channel. It's not an especially special or new channel. It's very good at breaking news. I would say in your crisis, if you have a public crisis plan, Twitter's going to have a role in that, but it's not going to be an over. Facebook will probably have a role in that, but you know, they're not necessarily primary channels because there are control issues there.
So I'm going to disagree a little bit.
Awesome.
We're going to keep things interesting. Social media, I think, we're talking about marketing now. I think I agree with what Greg said about you know, in a crisis situation. For marketing, I think it is useful. I think that if you have a unique voice, you can develop a brand. It's a little tougher for lawyers, but I think it can be done. I think that in terms of, yes, you're on Twitter, you're limited to you know, 140 characters. I think Twitter can be really useful, a useful channel. If you link it into your blog particularly, if you have a blog, you can go on Twitter. I mean, Twitter basically, that's what it is, it's microblogging. So you have the opportunity to expand on what you put there through other channels. So it's sort of a little, using it as a little leader for other things that you're doing. I mean, but the way that most people use Twitter, you know, sort of following celebrities and following brands and product, that's not probably going to be very useful for you. But there are ways in which you could use it.
You know, if you're making a list of people to follow, why not follow reporters who are covering areas that you practice in? You know, without backing one iota off of my hatred of Twitter, I will say that it is beloved by many journalists who use it to talk about what they're doing and what's coming up and to ask questions of potential sources.
So Greg, to piggyback on that, and then we'll get back to Weatherly, you had mentioned before, maybe about a half an hour, 45 minutes ago, about pitching a story via Twitter. Is that an appropriate way to really reach out to a journalist for the first time, is via not just Twitter, but just social media as a whole, maybe Facebook?
I always ask. I ask for preferences. You know, if I'm good, you know. But then again, I'm the guy on a first date asking, you know, where you'd you know, what kind of food you like if you're going to go to dinner. You know, some journalists want to be pitched on Twitter, some don't. I have sent many tweets to journalists saying, got something I think you'd be interested in, want it here or in your inbox. They'll let you know.
And then Weatherly, you had a comment.
We kind of skipped over this earlier, and I do think social media is important, but about like how do you get to be a columnist or something? I think Bill Marler's a great example. He's made himself a celebrity outside of the attorney world because, you know, he has food safety news. So anytime you Google a food safety story, you're really going to Bill Marler's website, sort of, you know. That's his blog, essentially, and he writes a lot of columns and everything. And so, yeah, anything you can do to sort of, like Keith's saying, build your brand is great. And certainly, again, Mr. Marler's a good example of you know, he's built a brand, and now, you know, people know who he is.
So show of hands, who here and the people in the audience are on Twitter, out of curiosity? Raise your hand, only a few. Who's on Facebook? Who has a blog? Who's on Pinterest? Who's on Instagram? All right, guys. So for those of you who are on social media, or are thinking about being on social media, the question for the panelists are, how do you find clients using these platforms?
Well, I don't know if it was clear, are you on it for business reasons or are you on it for, you know, for So who's on Facebook? A lot of hands, but who's on it for business reasons? Many fewer, right? So it's tougher. Again, I'm a big fan of having a blog because I think attorneys are good at writing, and I think that that's a place that lends itself to attorney writing. And I think that mainly I advise using other channels as leaders for that, lead-ins for that, so that people direct you to your blog. But I mean, there are exceptions, and there are people who are really good on Facebook because they have particular practices that lend itself to that. Or I have she's not a client, but I have one friend who's an attorney, and she has a very cute dog. She's on Facebook with she does some pet law, animal law, and she's on Facebook with that and all the stuff about the antics of her dog, and it lends itself to her brand. And she's just very social on there, and that works for her. So I think it depends really what your practice is. There are going to be some practices that are, more useful. For food, I think, for example, if you're representing restaurants, and you can have a lot of visuals. You can use Pinterest, you can use Facebook, you can have things that have a lot of visuals. So I think that it depends, what you're doing, who your clients are, what are they on? What are they looking at? I mean, it's the same question for any kind of media, and social media is really no different. What are your clients reading? Be where your clients are.
I want to second the call for blogging, because it's content that you control that can, over time, if the content is of a high enough quality, achieve the sort of results that you get from third-party validation via public relations. If you blog regularly, Google appreciates that. And spend the money or develop the expertise yourself to have your site technically sound for search engine optimization. I really can't stress that enough. I don't mean going out and paying some shady service to buy you backlinks or anything like that. I mean, make sure that your content can be seen and is semantically correct from Google's perspective. Most people never venture beyond the first page of search engine results. So to the extent that you're blogging in order to develop business, you need to find out the phrases that people are searching for and make sure your content ranks for those phrases, ideally on that first page.
So even me, your director of Twitter, can get a little overwhelmed by social media and the time that it takes. And so, we all have to practice law as well. We all have other jobs that we are doing. So my question for the panelists is, how can we have our social media be manageable, like a manageable amount of time?
For any marketing that you do, it's a channel, and for any marketing you do, I think you need to have a marketing plan like any other business. And to me, a marketing plan means budgeting for both money and time, sometimes the latter being more important. So, if you don't have 50 or 60 hours a week to be on social media, then you're probably going to, at some point, once you have some level of success, you're probably going to need to hire somebody to do some of that for you. And we all know about celebrities hiring people to do their tweeting on social media. Sometimes that doesn't work out so well, but it's easier for them, and they have a lot fewer concerns. You're probably going to manage your content a lot more closely. I definitely would recommend that. But you can hire people. You can hire people to do things like web research to find topics for you. You can have people do good writers, and that's one of the things that we do, who can write things for you that you should definitely be vetting. But you should think about that and getting somebody involved in your marketing.
So
And all things being equal, make the decision to put your time and your expertise into content development. Actually getting it online and tweeting it and promoting it, it can be outsourced, and not to put too fine a point on it, that sort of tactical execution can be somewhat commoditized in the market, and it's cheap. You don't want to pay a guy like me to do that for you. But you can pay, you can find an eager junior person for a 2-digit number an hour rather than a 3-digit number an hour who can handle it very competently and very consistently.
I mean, I'm the person that I think if you're just focusing on your blog and Facebook and that's all you can handle because you're a one-man band or something, just make it really good. You know, you don't have to get one of those programs that says it'll post, you know, get this program and write one status and it'll post to Instagram and Twitter and this and that, because it just seems real canned. And, you know, people can really ferret that out. So just whatever you do, even if it's not a lot, make it high quality and have a lot of richness to that content.
So Keith, you were mentioning before about hiring someone, and I've heard this term. I've never worked with a social media consultant before, and I was curious if that's what you were describing, was somebody who is a social media consultant, and then furthermore, what does a social media consultant really do?
Yeah, I wasn't necessarily thinking about a social media consultant, Carrie. You know, I was thinking about, ideally you're going to be managing this content. So, whereas I think social media consultants, generally speaking, are people who are going to manage it for you, and they're doing things like SEO, search engine optimization, and timing and things like that. So I don't know. I think most lawyers don't need social media consultants. Just go ahead and come out with that, as opposed to other kinds of brands. The kinds of people you may be hiring are, I think like Greg said, a junior person who's going to help, develop ideas, or your PR person may help with ideas, but you don't want to be paying for too much of that for content development on social media. You're probably, one of the things you probably should be doing, you should be following current events, and I'm sure you are, and then it can be one of your channels. So a lot of what we do is when there's some current event topic, it's not one of your cases, it's not your client, and we help to get you quoted on that. One of the things that you can do is you can just develop like a list of bullet points, and you don't have to necessarily take a position or any kind of controversial position. Just here are the issues. Regulatory stuff is very important to all of you, and that's something that journalists are always looking to speak with lawyers. So when you do that, you develop some bullet points. You can write a short article, not something with a million footnotes, but something for maybe a trade publication. And along with that, you can also go out to journalists and say, hey, are you thinking about, or I know you're writing about this, maybe you haven't considered this angle. Then you can put that on your social media channels as well. So one of the things you can hire someone to do, could be a junior person, is just to sort of help you keep an eye on these current events, because while you're busy with your practice, you may not have time to read every single trade publication or scour the web.
No, I would agree with that. I would say that, to the extent that you don't take the panel's advice and go searching for a social media consultant, that is an area where there's a great deal of snake oil these days. Get references, get case studies if you do this.
All right, so that is all the questions that I had, and so now I would love to hear the questions that you guys had, and if you don't have any questions, I'll keep making stuff up. So. Anybody have any other questions? All right, so here's my next question, and I skipped this one earlier. It was about having a column. I have wanted to have a regular column in a LifeSec publication for quite some time, but here's the kicker, is I wanted to get paid to do it. I didn't want to do it for free. And I have not had a problem getting people to say, yes, we'd love for you to write a regular column, but so far nobody who wanted to pay me to do it. So how could us as attorneys get those paid columns in maybe a trade publication?
My reaction to that is to chuckle dismissively. No offense.
Okay, great.
But with the media in general moving to a free all content is free, and I don't just mean the producers of the content are not getting paid, but consumers don't expect to pay for content. There are fewer print pages than ever before for that to go to. It's just and journalists and writers, since time out of mind, have been paid starvation wages because they love what they do and they will do the work for next to no money. I would say that is a very, very heavy lift. And if you were my client and that was like something you dreamed of, what I would say is, let's go start a blog, let's build that brand, let's build that column and make it so incredible that your audience is then actually what you're selling when you go to a publication and say, hey, here's this thing I built online, let's get it into print.
Exactly. You have to be a business proposition for them.
Yeah, you have to make yourself a celebrity.
Ugh, so much effort.
You write something very entertaining and be essentially a celebrity. Unfortunately, it's really difficult for lawyers, especially because, because you have ethics concerns. So there are many times you can't be so entertaining. You have to be careful what you say.
On the other hand, a lawyer with no ethics concerns is really entertaining.
You could get a column, but
Said?
if you don't mind you being
Yeah, if you
disbarred.
don't mind that whole bar thing,
You
it's
don't
great.
mind.
Even publishing a book, for most authors, since I am one, I can speak to this. Most of the time, what you publish is mostly it's a public service, and what you get paid is fairly nominal.
That's right. The value of a book today is it gets you in the door for speaking engagements. It gets you some recognition for opening a few doors. It's certainly in the nonfiction market, you have to have a breakout like the 4-hour work week or something like that before you're going to make the kind of money that matters off a book.
So still hoping for the ag law book that's gonna make a lot of money. So the next question that I skipped over earlier was, does anybody else in the room, besides me, maybe I'm the only one with these kind of dreams, but would like maybe a local news station to be the one that they call for an interview on TV, like someone who wants to be a commentator? How do those lawyers get on TV? What's the path?
Find you. I think usually it's back to what they were talking about. Like we find, we go through the Rolodex, and if we, as a desk editor, if I know that one of my reporters interviewed you and you were good and you had snappy answers, we'll call you to come in. But I don't want somebody that's going to choke. So if you're a known, you're more likely to get a phone call, unless you're the only expert on whatever it is, and then I have to call you.
And that scales up to a national level as well. If you're an expert in a very specific area of law, and you can demonstrate that you're good on camera, let's say CNN wants you to do a talking head shot as part of a package they're putting together. They're going to have you go down to one of the local stations they've got an agreement with. You're going to sit against a green screen, maybe in a studio, maybe in an extra broom closet. I've seen some pretty small satellite rooms, and do that talking head shot, and it'll have a lovely image behind you. But it's like starting on a farm team and moving into AAA and then eventually getting to play for the majors. But it will only work if you're good. The effort that goes into trying to become a trusted resource for the media once you're into visual media, or even broadcast, radio, the same way. You have to have a certain quality to your answers. It's not merely the expertise you provide. And that's probably another argument for some media training for those who want to pursue that path.
Ted?
I do quite a bit of this. I'd say first that giving a decent presentation in a studio where you're all alone in front of the camera is a good skill.
Oh, yes.
You gotta practice it. It's weird.
Right.
It's definitely about giving snappy answers, and I would take it even a step further from what was said. And you don't even have to. Could be good news. You don't even have to be an expert necessarily in the area they're talking about. I mean, we have clients who, more than one, who are now on national media fairly regularly, talking about things that they didn't really know that much about. But particularly if it's a litigation matter and they're a litigator, they don't necessarily have to be an expert on that. But they're good on camera. They just called the journalist. They know they're a known quantity. Also, they're available. They'll come in, and then they'll do a little research. I'll do a little research about that case. I didn't know about it, but it's in the news. And the next thing, he's on CNN the next morning because he's just good on camera. So if you're someone who's good on camera, you can go talk about anything really.
Yeah, and if, you and that reporter have a relationship, I'm going to call you, but if you don't answer my phone call or call me back in 5 minutes, I already call the next guy. So just remember that and make sure you have my name in your phone.
And
kind
that
of thing.
stresses me out, just so you know.
Well, we're on a deadline, we're on a deadline. This isn't like, if I'm broadcast, I got to have my story done in like, an hour and a half. I'm not print. I don't have till midnight, so.
And Ted?
That point is excellent. If you don't call reporters back right away, they keep calling.
Yeah, because I already got a new guy.
All right. Oh,
One more thing to add. There is training available to do this. By far the cheapest is the Toastmasters organization, and the Toastmasters clubs everywhere. And when I go to my local Toastmasters meeting, you get free critique.
Oh, that's great. Good idea.
yeah, I've heard good things about Toastmasters. Has anybody else participated in a Toastmasters?
Yes, it's good. Good practice.
Do we have any other questions from the audience about multimedia? All right, we have a question over here.
About multimedia.
What about it?
I was just going to talk about the trade press. We talked about all sorts of press today.
Mm-hmm.
And, in my history, I've done a lot of work with trade press, particularly in terms of hopefully using it to my client's advantage. The relationships I've managed to build with press people over the years have been primarily with trade press, or like you said, with people on specific feeds.
Well-
Because and often that relationship is built not necessarily in helpful to my client on day one, but it's because they're seeking knowledge. And particularly the trade press doesn't want to write something wrong.
Right, and they're typically staffed pretty thin. They don't have a wall of reporters.
And they're great about not quoting you if you make that clear.
Yeah, you've got a nice, those are nice people to work with, because they're not necessarily trying to find the other side of the story,
Well, or even if they are, they're still good, because to me, a relationship, if you're in that area and you need them, they are also a source of information for you. Because they, at least most of the ones I've worked with, tend to believe they need to bring something to you for you to kind of go back to them. And so over the years, there have been some very profitable two-way relationship with trade press. Again, someone who's not bent on quoting them. They'll quote you as a source, but they just won't put your name.
So what about multimedia?
That wasn't about
Oh,
multimedia.
he was saying it's not about multimedia.
It wasn't multimedia. I was just talking about, we talked about a lot of press here today. How much over the years I have found the trade press to be helpful to me and so my clients.
And trade press, while still holding on to their editorial integrity, will often cut deals with you in terms of your own thought leadership content that you'd never get from a mainstream publication. I have a client that's a leading standards setting body. It's a nonprofit, and we give them a full page infographic every issue that shows some data behind some pressing issue. That, other than correcting for the occasional typo, they don't touch that content. From our lips to God's ears.
Which is bad reporting.
You never get that out of mainstream content.
Say that loud.
I hate trade press. I subscribe to all of it, but it's all biased, so.
Well, and I guess there's two types. I guess I could even clarify beyond that. There's the trade press, like, for example, the cotton industry, or Cotton Farming Magazine.
Yeah,
or
Southeast
the
Farm
ag
Press.
press is the most wonderful press I've ever known, generally if you're in agriculture, because they tend to be on your side. They tend to be on the
Oh,
farmer's
yeah.
side.
Sure.
And they're also great about sending you articles and letting you fix your quotes.
Yeah, that's bad, but
Now,
yeah.
the other trade press are the ones who are selling trade publications. I mean, they're selling information on trade policy, or they're selling information on chemical policy, or they're selling it to clients who buy their services in order to get information. But then they get quoted outside of that, or at least the stories that are generated in there, can become catalysts for things. trying to
Absolutely.
drive, as long as you don't mislead them. But, you know, you're just,
And a lot of struggling trade pubs are moving toward more of a pay-per-play model. So it's one of the things, you know, you get that call one day from a sales rep who, you know, says, you know, yeah, I know you've been talking to our editor. We'd really love to cover this. Hey, have you considered advertising? And the message is implicit but clear. And, you know, in industries that are not consolidating, it's less of a problem. But in the cleaning industry, where this one nonprofit I work with is at, they've had a lot of consolidation in their trade press, and now it's down to a couple of pubs, and they've figured out we can ask her anything we want, and they are doing so.
Yeah, we do a lot of work with trade press. I think, you know, that's some of the most valuable relationships that attorneys can have, and your clients are all reading it, and so it's really good to be in there. Sometimes it could be better than a lot of the mainstream media to just be in the trade press for you. So we definitely encourage you. You know, I agree with everything that was said about, you know, editorial versus advertising, and there a lot of the content can skew towards advertising or advertorial, you know, you will get deals that you're not going to get. You may get the opportunity to, for example, do something like a Q&A where it's written. You have everything in advance, and you can write it, so you fully vet everything. You can get a lot of control over what's nominally editorial content. So it's very useful. I understand.
I have one last question before they kick us out of the room and we're off to our next section today. And I breezed over this question before, and we'll just have a brief answer. For someone like me, I'm a kind of a solo in 3/4 with a small PR and marketing budget. We have some other attorneys in the room with larger PR and marketing budgets. What exactly can PR professionals do to help attorneys that are sitting in this room?
To help with?
Yeah, just
With
to help.
anything.
Yeah. And is it anything? Like what?
Yeah, and all the stuff we've been talking about can help with we do, for attorneys, we help with business development, basically with marketing, but we're also helping on their cases, and then in that sense, we're really an added value for their client. Once we're on retainer with them, sometimes they can tell their clients, look, here's a free service for you. You have a problem. We're going to bring in our PR counsel. And then, you know, we didn't cover this exactly, but on the ethics issue, if you're doing, and also in terms of not breaking privilege, if you have a litigation, you definitely want the attorney to be hiring the PR counsel and to be giving the advice in the context of the litigation. So obviously it's simpler with us. I am an attorney also, so it simplifies things, but you can, you know, hire you can hire qualified PR counsel, generally speaking, to give advice in the context of litigation. But you know, marketing and reputation management and added value for your clients.
All right. Greg, do you have something briefly to add?
The nature of all consulting is that you're hiring people with highly specialized expertise to come in and deliver a solution, because to develop that solution internally would take too much time, too much effort, you know, distraction from other resources. Those of you who are practicing in your own practices or in law firms, I mean, that's your model as well, right? You know, that's why corporate counsel sometimes hires outside counsel. I get hired when clients want to get across a given finish line. Maybe that's business development. Maybe it's helping with a case in crisis. Maybe it's developing a plan that they will then execute internally. I don't make those value judgments for clients on what is and isn't worth their time. But once a client decides, this is worth my time, this can be done quicker and with greater expertise by hiring somebody outside, that's the point I get engaged. And it would look different for every person in this room.
All right. Thank you very much for your time and attention. I appreciate it.
Good, well done. You said very smart things for a long time.
If you want any handouts with lists of journalists or other things like that, we have some up here.